Good evening, all. Thank you all for being present here, especially my former brethren, honorable judges, the honorable judge sitting on stage, my very dear friends on stage, all of them. Ladies and gentlemen, you couldn't have a better day to launch this book. This happens to be Dr. Ambedkar's birthday. He was born on this day in 1891, and he could justifiably be called the father of our Constitution. I must also hearken back to just one day previous. 13th April is perhaps the blackest day in our history, which we must never forget, because on that day in 1919, Reginald Dyer, a British general, took our own troops in Jallianwala Bagh and actually fired at and killed and hurt a very large number of our citizens. And that is exactly the point of this book. Can that ever occur again in free India? This time, by Dyer being replaced by one of our own generals or police captains and doing this to our own people. Obviously, it cannot. And the reason it cannot is because, in large measure, of this great doctrine which the Supreme Court has laid down to save us from constitutional amendments which may allow such things. If I may begin at the very beginning, the very first amendment was the subject matter of challenge. The first amendment amended a number of provisions, curtailed fundamental rights, and contained one very draconian provision, 31(b). Now that provision essentially was like some kind of residue in the Constitution where acts which were actually struck down by the Supreme Court would get resuscitated. It's an amazing provision. I mean, when one sees it, the moment you insert, you being either Parliament or the state legislatures, insert an act into what is called the 9th schedule, then not only is it protected from harm, so to speak, and what is the harm? The harm is fundamental rights being enforced by courts, all of them. Having been then so protected, it goes on to say that even if something has been struck down by a superior court, including the Supreme Court, that judgment is of no avail, and the section, act, or whatever it is bounces back with full fury against the citizens of this country. Now, surprisingly, nobody really focused on 31(b) in the very first case that was heard, which was Shankari Prasad Singh Deo's case. And Patanjali Shastri Ji, who delivered judgment, said this, and said, as a matter of fact, surprisingly, the only argument raised against 31(b) was that it required ratification by the states, which was not done, since it affected various articles of the Constitution, including 226. And that was turned down by the bench. But then the bench went on to issue a caveat at the end saying that this appears, particularly in the second part, to be overbroad. But at the moment, nobody said anything about it. We leave it at that. What Shankari Prasad Singh's case actually did was to look at Article 13, which says that the moment there is a fundamental right which is impacted, infringed, then any law made by the legislature will naturally give way to the fundamental right. But then they said that, look at 13 and then look at 368, which is the power to amend. And ordinarily, since 13 is an inclusive definition, it includes various laws and would therefore include constitutional law as well. We have to harmonize it with 368, which is the power to amend. And if we harmonize the two, then it is clear that 13 must give way to 368. Now that was the vision for about 15 years, until finally in Sajjan Singh's case, again, the 17th Amendment got challenged. There were doubts cast on Shankari Prasad by 2 learned judges. And an 11-judge bench then convened, which was in the celebrated Golaknath case. Shankari Prasad's vision of Article 13 giving way to Article 368 was overturned. And therefore, in Golaknath, what was said was fundamental rights from this point onwards are sacrosanct and can't be touched. Constitutional law and constitutional amendments notwithstanding. Unfortunately, the razor-thin majority in Golaknath, because that was by 6-5, also added that the power to amend is located not in Article 368, but in the residuary power of legislation, which is a little far-fetched and difficult to accept. That being the weak point of the judgment was then undone by constitutional amendments that were made in 1971, in particular the 24th Amendment. And after it was undone, Golaknath's case itself came under scrutiny. And that's how Keshavananda Bharati's bench was formed, the largest ever of 13 learned judges of the Supreme Court. It is interesting to note that of the composition, 6 senior judges were Chief Justice Sikri and Justice Shelat, both of whom belonged to the Golaknath bench. Then Justice Hegde, Justice Jagan Mohan Reddy. And each of these judges, senior judges, all voted in favor of basic structure. It is only one senior judge, Justice Ray, who voted against and had been consistently voting with government in the last few cases. On the other hand, the junior judges were exactly the opposite. Those who had just been appointed post-71, and all of you remember there was an election in 1971. And what was done away with was a very healthy convention. The convention was that the Chief Justice will ask the government to appoint somebody, and unless there was an objection, that somebody got appointed. Here it was turned on its head. And what happened instead was that it's the government now who sent names to the Chief Justice and overrode the Chief Justice as well. And that happened in 2 cases specifically, in the case of Justice Beg and Justice Dwivedi, both of whom came up. So we had now an array of 6 senior judges, 5 voting for basic structure, Justice Ray standing out, and 6 junior judges, 5 of whom again voted against basic structure, with only Justice A.K. Mukherjee holding out, who joined Justice Hegde. The pivot, of course, was Justice Khanna, who was the judge exactly in between. Now, this case spanned some 66 days of argument. We are told that originally the petitioners went to Mr. Chagla, who had retired by then, and asked him to argue the case. He said he was too old, and then he requested Mr. Daftari to argue the case. Mr. Daftari also demurred. And then they finally said the only man who's capable of doing this is Mr. Nani Palkhiwala, and that Mr. Chagla must use his good offices with Mr. Palkhiwala and get him to do so. Mr. Palkhiwala was not at all enthused, but then ultimately could not refuse Mr. Chagla. The result was that a couple of weeks before the hearing was scheduled, Mr. Palkhiwala was brought to Delhi. He had no notion of what he was supposed to argue. And he locked himself apparently in a room in the Oberoi. And he had a huge team with him. He never met the team. He only got notes from that team, which he asked for from time to time. And he had a couple of judgments, including the SCRs, put in his room. And he just locked himself up for about 2 weeks and prepared the case. And then when he started, apparently it was extremely difficult for him to get a word in edgeways, because all 13 judges, or at least a majority of them, started almost speaking at the same time and jumping on him. And this happened for about 2 or 3 days. Fortunately, Chief Justice Sikri met Mr. Daftari at some dinner party. And he asked Daftari, how do you think the hearing's going? So Daftari, in his inimitable style, said, it's going very well. It's a matter of fact. There was an American tourist who came in the other day. She was most impressed by these 13 wise men. And she was asking, but who was that young gentleman who kept interrupting them from time to time? Chief Justice Sikri got the message, and day 4 or 5 onwards, the thunderclouds vanished, and Palkhiwala was allowed to argue. He took 31 days and spanned almost every country, certainly every continent, must have cited in n number of cases. And ultimately, when he sat down, he sprung a surprise on Sirvai, who was the Advocate General of Maharashtra, appearing for the other side, together with the learned Attorney General, who was Mr. Niran Dey. Now, there again hangs a tale, because the government of the day was very keen on Sirvai starting and not the Attorney General. And that was completely wrong. So there was animosity between the two of them, until finally it was made up thanks to a tea party in my father's chamber. My father was Additional Solicitor General at the time and hosting Sirvai to lunch throughout all this. And the animosity vanished, and then it was agreed between the two of them that Mr. Sirvai will start and Mr. Dey will be held up in some conference or the other, so that he should be allowed to start. Then when they started, they took something like 34 days, the two of them. And finally, on the 66th day, it was Palkhiwala's turn for rejoinder. And Justice Beg fell ill. Now, that was one other big thing that happened, because there was a deadline, and the deadline was Chief Justice Sikri's birthday, 25th April 1973. And we had already reached March. So, Justice Beg's illness prevented Palkhiwala from starting his rejoinder. And as a matter of fact, when they assembled again on 23rd March, Palkhiwala said, doesn't matter, I will forego my rejoinder, I will put in my written submissions. And finally, Justice Beg got well again, because it was in the balance as to whether Justice Beg would now actually vote, not vote, whether the case would go on, not go on. So it almost never happened. And finally, one day before Chief Justice Sikri retired, 11 judgments were handed down. Now, as soon as they were handed down, we found that the only common measure among 7 learned judges was the fact that there was something called a basic structure to our constitution. And the 7th judge, Justice Khanna, did not agree with the other 6 judges on what the other 6 judges described as implied limitations. Now, I always thought that suppose they had used the expression inherent limitation instead of implied, it would be much, much easier, therefore, to settle in a mind, because it is then easy to say that, look, you have to read the power to amend a constitution in the setting of a constitution, and you have to see the setting in all the other articles. So there are inherent limitations when you look at the pattern of government in all the other articles. That becomes much more palatable, but somehow or the other, the word inherent was never used. And implied got stuck in the throat. So implied was knocked out by 6, knocked out by Justice Khanna as well. However, as a matter of construction of the word amend or amendment, ultimately, 7 learned judges, fortunately for us, all said that amend is used in a narrow sense. They adverted to the Attorney General and Mr. Sirvai's concession, which is that you cannot repeal the Constitution simpliciter. Now, if you cannot repeal the Constitution simpliciter, something has to remain. What is that something? That something can only be basic structure. So this was the kind of logic that was used. Now, close, and before we finish with Keshavananda, in fact, there's one other very interesting thing I adverted to in the book. One part of Article 31C, which I must tell you all, accords primacy of 2 directive principles over fundamental rights contained in 3 articles. One part, the last part, precluded there being even a judicial review of whether a law made by the legislature has made a declaration which is correct or not in law. Now, how do I explain myself? The declaration has to state that, look, I, the legislature, look at the directive principles contained in 39B and C, and in furtherance of those principles, I am making this law. Now, suppose the law had nothing to do with those directive principles. Even then, judicial review by courts was eschewed, it was out. So this part was struck down by 7 learned judges using the basic structure doctrine for the first time in Keshavananda itself. What is equally interesting is 4 of the minority judges out of 6 all said that this part will not obtain without giving reasons. Now, obviously, it cannot obtain only if there is a basic structure, which is the tool with which you can say it cannot obtain. But that was inconsistent with their judgment, because their judgment was there is no basic structure. And if there's no basic structure, they should have gone the way Justice Ray and Justice Palekar went, which is to say, yes, in which case constitutional amendment cannot be touched, over, end of matter. But this was the infirmity of 4 learned judges from the very start. And they are all minority judgments. Each of them says, no, that last part will not obtain. Why will it not obtain? We are not told. But anyway, they left it at that. Now, after Keshavananda's case, we had a test case in Mrs. Gandhi's own election judgment. And what was done there was truly extraordinary. She lost in the Allahabad High Court, and her appeal was pending here. When the appeal was pending, there was a 39th Constitutional Amendment Act which was passed. It was truly extraordinary. It was an Article 329 capital A consisting of 5 sub-articles. Sub-article 4, in short, only said that the appeal that is pending now of the Prime Minister and an imaginary speaker, because there was no speaker appeal pending, the appeal pending of the Prime Minister will be decided without applying any law. Truly extraordinary. And it will be allowed under Article 5 by the Supreme Court by applying subclause 4. Now, the bench which heard the case consisted of 4 minority judges in Kesavananda. Justice Khanna being the only member of the 7-judge bench majority. 4 minority judges said they were bound by Keshavananda's ratio, and each one of them used the basic structure doctrine to knock down this amazing article. Chief Justice Ray was forced to knock it down, saying, look, this offends the rule of law. It can never be that an appeal can be decided by applying no law. So on that short ground, it was struck down by him. The other judges each found some facet of basic structure to strike it down. Justice Khanna said free and fair elections, part of democracy. There has to be an election tribunal, which goes into the facts. Here, nothing is gone into. No law is applied, therefore bad. Justices Matthew and Baig both said the constituent power, whatever it is, cannot exercise judicial power without first granting judicial power to itself. And here it purports to exercise judicial power without ascertaining facts and without applying any law. So, out the amendment goes. And finally, Justice Chandrachud held that it offends Article 14, which is part of the basic structure, in that the Prime Minister and the Speaker, for no intelligible reason, has been put above everybody else who has lost an election. Now, one very interesting thing happened. In fact, 2 very interesting things happened after Indira Gandhi's case. One was that Sirvai, who had all along stuck in fact doggedly to his theory that there is nothing like basic structure, completely changed his mind. And he said that the difference between Indira Gandhi's case and the earlier judgments was, this was the first time basic structure was used in a non-property context. First. And second, what was considered in Kesavananda to be things which are outlandish and which can never happen have actually happened. So something outlandish has actually happened, as a result of which he changed his mind and became a great votary of basic structure thereafter. Another very interesting thing happened immediately after. The moment these judgments were delivered, within 3 days, a 13-judge bench was reconvened, this time, to say that basic structure should be revisited. Now, Chief Justice Ray reconvened the bench with a number of other junior judges who had just come in. And we are told that he kept on saying that it has been reconvened at the instant first of Mr. Palkhiwala's client, who was again brought to re-argue. And Mr. Palkhiwala said, I wouldn't be out of my mind to ask for a reconsideration of basic structure when I've succeeded on this. So the Chief Justice was put into a corner and then said, no, but then Tamil Nadu has asked for it. And to his great credit, Mr. Govind Swaminathan got up as Advocate General and said, we have done nothing of the kind, we support basic structure. And then he got further into a corner and said, very well, then the state of Gujarat has done it. And the Gujarat Advocate General got up and supported Govind Swaminathan and said, I have done nothing of the kind. So the net result was that there was a revolt then within the judges themselves, and abruptly the second day of argument, Chief Justice Ray walked into court and said, bench is dissolved. So the first attempt to undo Keshavananda failed. The second attempt was in the Constitution 42nd Amendment, where by adding 2 subclauses to Article 368, the amendment now specifically said there is nothing like basic structure and no constitution amendment can now ever be challenged in a court of law. This was struck down in the celebrated Minerva Mills case later, saying that suppose there was a procedural infirmity, not substantive. Suppose, for example, 2/3 of each House of Parliament present and voting was in fact not present and in fact not there when the amendment was passed. Or suppose it needed ratification of half the states and only 1/3 the states are ratified. Even then a court can say nothing. So for that reason it is bad, apart from any other. So the second attempt also failed. And once that second attempt failed, this doctrine has been used n number of times right till the present to strike down arbitrary and excessive constitutional amendments. I may tell you only one thing, that when Mr. Palkhiwala began his argument in the original Keshavananda Bharati case, he was desperately looking for some judgment in some jurisdiction which would, as a matter of fact, apply here by saying that an amendment can be struck down on substantive grounds also and not procedural. There wasn't a single such judgment. And all that he could rely upon was a speech given by a German professor, Dieter Konrad, from Heidelberg. And that speech became an article. And in the article, Dieter Konrad gave 4 extreme examples and said, suppose Article 21, which is the right to life and personal liberty, is removed. It can be removed by a simple majority of 2/3, no ratification needed. Is that something that one would envisage with a democratic constitution? Suppose you were to bring back Mughal rule, or you were to bring back the British king and replace this monarch with the president. Could you do such a thing? And then he said India has to be a union of states. Suppose you just do away with all the opposition state governments and say there'll be only 2 states and nothing else. And best of all, the most telling example was the 4th example, which was, suppose you were to give the power to amend to the executive. So far, Parliament had to have a 2/3 majority in each house and ratification by states. Suppose you were to remove that and say, no, give it straight away to the President of India in his executive capacity, and an executive order can do what it likes with the Constitution. Is that something that was envisaged, or was it not envisaged? So that was all that he went to the court for, with. And it is remarkable that he succeeded with only this article. Now that it has been laid down, it has been picked up by a number of other countries, which I have also adverted to in the book. So I leave now all of you with Mr. Datar, who will conduct the panel discussion for you to delve further into this doctrine. All I can say is that the endeavor of this book is that this doctrine has come to stay. It can never go. And if by chance it ever goes, God help this country, Jallianwala Bagh becomes a distinct.
I just enrolled. Good evening, everybody. I just enrolled in the bar, and I was a briefless lawyer, so I would normally go from court to court watching judges. And when I heard that this matter was on, I went to court 1. And there I saw Nani Palkhiwala arguing. And the one thing that struck me was that he never looked, though ROHINTON says that he cited several law books, but while I was there, he hardly referred to any law books. His understanding of basic principles of law, his felicity of language, his love for literature, he just mesmerized the court by telling them the differences the differences between meanings of law and the Constitution. What does law mean? What is the Constitution? Basic principles of law he enunciated with such great clarity that anybody who was in court was just mesmerized by his forensic abilities. And quite frankly, I have also had the privilege of helping him in some cases. And what I found was that Nani never really cited the law to make the law. He, in fact, made the law by not citing the law. He had the ability to encapsulate principles of law which do not find place in any judgments. And then that's how he developed sales tax law, that's how he developed income tax law, that's how he developed constitutional law. And I remember when the review took place, he argued for a couple of hours, and he didn't look at any book. He referred to no book. He just argued for 2 hours non-stop, and nobody could ask any questions from him at that point in time. So he overpowered the court by just his presence. And he never hesitated on, when a judge would ask him a question, he would have a ready answer for it, and a very fine answer for it. So what I learned from him, and I think all lawyers, and this is what I wanted to say today, all lawyers learn that lawyers are meant to develop the law. If you start looking at judgments and start now looking at the law and say you must follow this law, you'll never be able to develop principles of law. So the one thing that we must do when we go to argue, and this is what I learned from Palkhiwala, and I followed it, I've followed it all my life. Look at the facts, know basic principles of law, and develop them in the context of where you want to go and where the legal, where law should be, because ultimately law is a vehicle for change, and new situations come up in the country which require change. And what ROHINTON has said, and quite frankly, today the basic principles are here to stay. The basic doctrine is here to stay. Nobody can change it. In fact, Article 359 of the Constitution itself says that even in a national emergency, Article 20 and 21 will remain in force. Now, once there is a constitutional provision which says that, nobody can change the basic structure of this country. But the real challenge, and that's why I want to start to this discussion, is that you don't need to violate basic structure by changing the principles of basic structure. You can violate basic structure by bringing in ordinary law, which is contrary to the basic structure of the Constitution. And the principle laid down in Keshavanand Bharti is that basic structure is only a concept which is applicable to the constituent power of Parliament. But if you have laws which are contrary to the basic structure, you can't challenge them on grounds of basic structure, but you can violate basic structure on a daily basis, and that's what's happening in this country.